It's about the fact that it's about the vaccinations, whether or not the vaccinations infringe our rights and whether they've been properly implemented. And it is actually partly funded by Simon Dolan, who is a COVID skeptic and has funded other COVID litigation. And I think that is relevant, actually, because they've also been crowdfunded. And I think that all of you who provide care should be aware that that sort of funding is out there. In addition, I'm sure yesterday you saw the letter from DHSC issuing the temporary medical exemption form. It's a self-certification process that will be used until the COVID pass system's up and running. We've already had loads of questions about it, and the questions are along the lines of why don't people have to show medical support for their self-certification? And in addition, there is a worry that people will use it to extend their employment if they are not vaccinated, which is really interesting. I think that this is very early stages, and of course one shouldn't assume that all staff are trying to get around
How can I help you?
Get around things. Can I remind people to go on mute? Thanks. But it's an interesting development. The self-certification certificates, temporary, can also be used for those vaccinated overseas while they sort out what's going to go there. But really interesting also for pregnant employees. So that's the first sort of acknowledgement that perhaps pregnant employees, a lot of whom I know are very hesitant about having vaccines, might be able to avoid having vaccines. There was also a BBC report today, I don't know if you've read about it, about the impact on women and their menstrual cycles of having the vaccine and having COVID. So there's obviously something going on which is quite interesting, I think, scientifically, I mean. Someone has asked a question about when the judicial review is likely to be heard. I don't know. What would normally happen is you'd have a hearing when they decide whether they have permission to pursue the judicial review, and then it would be listed for a substantive hearing. But because the legislation comes effectively in on the 11th of November, I suspect there will be one hearing, and the courts generally take a couple of weeks to sort out a date, and of course the barristers have to be available on those dates. So I would have thought before the 11th of November, but I don't know, Robin. And Amanda's asked, is the pregnancy self-certification applying to women undertaking IVF? It doesn't say that, but maybe another of the people on this call will be able to answer that question. So broadly speaking, I act for about 50 care providers. Some of you are on the call, I think. So it is, sorry, I'm looking at the chat now. Yes, Lisa, you're right. Of course, the letter which came out said previous advice was pregnant with a medical reason would be exempt. You still, if you've got a medical reason, an IVF might be one of those. I think that is possible. And I have seen medical certification about it with someone going through IVF, so that is definitely a possibility. I think it depends at what point you are in the IVF cycle. So broadly speaking, among our clients, fewer not vaccinated than expected. I'd say overall, about 10% of people are not being vaccinated within care among my client base. Now, I know the government is anticipating the target will be about 7% not vaccinated. But of course, today is the last day for your first vaccine if you're going to hit the 11th of November. There's still major operational issues about recruitment, and indeed, Martin England, who I think is a speaker today, was on Radio 4 this morning talking about that. It's a big issue. And I would say among most of our clients, redeployment is not a possibility. They don't have jobs for frontline care staff in other services, the majority of them, which is interesting, but reflects probably the fact that care homes are very often, a small entity in a sense that run 1 or 2 care homes and don't have much else. So you'll also be aware that there is a proposed extension of the law so that there would be new regulations, and they're proposing bringing them in the same way. So it would be effectively something for CQC to monitor and police, to extend to all health and care settings. And that means anyone deployed to undertake direct treatment or personal care as part of a CQC regulated activity. They're also looking to extend the condition of employment to cover flu jabs as well. And there is a consultation that is open. Now, it won't apply to some CQ services that are not that aren't delivered face-to-face, like remote GPs, for example. We're all complaining all our GPs are remote, but I think some of them, I mean, obviously the more modern ones are just remote. And then there is a discussion about whether or not that total requirement that people who are deployed are vaccinated should apply to a full range of services, including hospices, residential recovery for drug and alcohol services, registered extra care and supported living, which I think is, I know a number of you have large undertakings in, and registered share lives. So it's quite a broad opening up. And the reasons for this, the sort of clinical reasons for this is what other governments are doing. And also it's seen that it would be a good thing to have parity, so that people providing services that are after vulnerable people are similarly protected. And that's a reflection that there's a lot of crossover, and a lot of individuals who are supported are crossed over in terms of the support they get, but also a number of the employees who are working, or the people who are volunteering, or workers who are deployed, are often deployed in more than one of those types of sectors. So that's the real sort of driver behind this. And also the fact that the government thinks vaccination is a good thing, and it's very difficult to argue that in view of the figures of people whose lives have been saved. The consultation also looks at whether it should apply to under 18s and those who don't provide care, like porters in hospitals, for example, or meal givers, and people who are on the periphery of providing care, who come across people but perhaps don't provide that care. So the consultation is actually very interesting. The consultation document is much wider than the consultation that we looked at earlier in the year that brought in the regulations relating to care homes. It's much wider, and it does, I think, take much more account of the effect on care providers. It's really important that everyone responds to the consultation. And it specifically states, consultation, in the consultation document, we intend to discuss the impact on individuals and employment law consequences. And that wasn't considered in the first round. So I think it's a good thing that they are consulting. The timing of the first consultation was really, really fast. I mean, it just didn't give us enough time to consider the impact on people. And when I was saying to people, well, if you've got employees who've been with you 12 years or more, you're going to have to give them 12 weeks notice to terminate. And that meant you should have given them notice in the middle of August, or you have to pay in lieu of notice. And that gives you yet another cost of implementation of this law. I was talking about this to someone within government, and they just hadn't realised that. So I think there's a real opportunity in responding to this consultation to ensure that some of the lessons learned from the first consultation are picked up. Having said that, I'm fairly cynical, lawyers generally are, and I would suggest that after if you look at the outcome of the consultation on the first set of regulations, it wasn't taken account of. The majority did not want enforced mandatory vaccinations, and they brought them in anyway. So we're also seeing loads of kickback. And in fact, one of the unanswered questions from a previous session, which Victoria's asked me to run through, is a bit about, what are you seeing in terms of kickback from employees? What we are seeing is the same letters, and I'm sure you are too. There are standard letters from principally the Workers of England Union, seeing a lot of those, the COVID-19 Assembly, and the Legal Advice Network. And what do you do with them when you get them? Well, our advice is you do need to answer them. You know that if you are going to dismiss an employee, you have to do it fairly. That means you have to have a fair reason, and I'll come on and talk a bit about that. But you also have to implement a fair process. And the fact that this is law does not mean that you don't have to do those things. You still have to go through a process and dismiss someone fairly, or you could be at risk of employment tribunal claims. Now, what I'm really worried about is the crowdfunding. You know, Mr. Dolan is funding the judicial review. What's to stop him funding a number of other claims? What about other crowdfunding? What about the Workers of England Union, which has been very, very voluble on this? So I think it is really worth care providers, you know, dealing with this in accordance with the law. And I'm surprised by how many conversations I've had, actually not with HR professionals, but with CEOs saying, yes, you do have to go through a process. You do have to dismiss someone for their employment to terminate if they don't meet the guidelines. So I think this is a big issue. So what we're advising, if you get any of these letters, is you need to take them seriously. Now, that doesn't mean that you have to go through a massive process, but it does mean that you have to consider them. And what we're saying is perhaps you need to think about whether or not they are raising a whistleblowing complaint or a grievance. Very often they're standard letters. They don't actually raise anything to do with the individual who's sending you the letter. It doesn't say, they just said it is discriminatory. It doesn't say it's because I'm a woman that it's discriminatory. It just says it's discriminatory. But sometimes they raise issues about whistleblowing, and it's sensible then to have some sort of response to them, which you may replicate many times because you may get many letters, which sets out exactly what your response is and also answers your whistleblowing procedure so that you're dealing with it. In addition, a few other questions that have been answered. Can you put the legal requirement to have a vaccination on your advertisement? Yes, you can. Second question, at what date can we serve contractual notice on staff who've confirmed that they won't be vaccinated? Well, we say you can do it as soon as you've been through the process, which is to have a meeting with the staff, consult with them about what you're doing, making sure that you've acted fairly, have another meeting when you do go through the dismissal, not just issue them with a notice or issue by, tap them by text, sit down, have a proper meeting in compliance with the ACAS code, and then give notice. And we're advising people to give conditional notice. So notice condition on them not having the vaccine by the 10th of November. So that if they do have the double vaccine by the 10th of November, then the notice falls away. Now, you also do have to give adequate notice to terminate, which is subject to the statutory notice period, which is 1 week for every year of service to a maximum of 12. And as I said earlier, the 12 weeks period has gone. You should have given notice in August. So that means, what do you do at the end on the 10th of November, on the 11th of November, if somebody hasn't worked out their whole notice? Well, you can still redeploy them if that's feasible. And obviously, if you can redeploy them permanently, that's what you should be doing. Or you're going to have to put them on leave and pay them, or pay them in lieu of notice. So that's the cost I was talking about earlier. And Victoria, have I got time for a few more questions?
Yes, there's a couple of good ones in the chat as well.
Okay.
So there's one from Ricky, which might be more of a comment. So he's asking, does that not imply that they're more reluctant to enforce the vaccination as a condition of deployment across all health and social care areas?
Ricky, I expect you asked that question when I was saying I think this consultation is much more thorough. Yes. I'm not sure. I'm not sure, to be honest. I mean, I think that they're doing this much better consultation, partly because it involves the NHS, because the NHS is our national treasure, isn't it? And I think it is potentially much more contentious than introducing it in the care sector. But having said that, the amount of vaccinated individuals within the NHS is much higher than it was when this was mooted in the care sector. I think at that time we were at about 78, sort of late 70%. And in the government consultation paper, it appears about 90% of NHS staff have already been vaccinated. So we'll see. Amanda says, I've received 3 of these, but they were the templates with no details about the employee in question. Do we still need to respond to the templates if they've no information in them? Amanda, that is common. I think people aren't reading them, they're just sending them on, to be honest. It depends is the one. It depends which one you've got. But ultimately, if they are raising issues in a whistleblowing format. So they're raising issues where they are making allegations which would count as a protected disclosure, and it involves it's in the public interest for them to do that, and a lot of them are drafted in that way, then I would deal with them as a whistleblowing complaint, because if you don't and you dismiss, the argument may be that you have dismissed because you are basically making the employee suffer a detriment as a result of their whistleblowing. Now, there are lots of arguments against this, and as I keep saying to employers, you will probably win any claims that you have if you follow a fair process. But if you don't follow the fair process, you're stuffed. And also bear in mind that the cost of defending a claim, even if there's no merit in it, is dreadful. So it's worth going through the process just to avoid any fallout there. Sam Lee says, does this apply to domiciliary office-based staff? It applies, no, the new consultation will apply to domiciliary services where people are providing the services. So if you have carers who are based in an office and then go out to provide domiciliary support and it's CQC registered, yes, it will apply. If they are, the receptionist, it won't apply. Claire says, we have one employee who has refused vaccination. She's worked in our organisation for 19 years. We are dom cared. When should I start looking at meetings to discuss adequate notice? Now, Claire. Especially if she hasn't been vaccinated today, because she won't be vaccinated in time. So you need to have a consultation meeting with her as soon as possible. So a few people have asked questions about what you say to people. Why are you dismissing them?
Yeah, I think Nathan's right. That's domiciliary care, which is
yes, you're absolutely right. Yes, it'll be covered by the proposed legislation. Domiciliary care doesn't apply yet. You're quite right, Nathan. Yeah, exactly. Alison's just made that amendment. Yeah, sorry, I was eliding two points there. So yes, so the other things were, what do you say to people? Now, you will probably know that if you dismiss someone, you have to have a fair reason, and there are 5 fair reasons in law. And I think 3 of them apply potentially. One is illegality. So it would be in contravention of an enactment to continue employing somebody. DHSC has suggested that it might also be some other substantial reason, which is a sort of catch-all provision. And I think there's also a capacity issue. Is if you can't employ somebody because they don't have the capacity to be employed, because they don't, for example, have a driving license, or in this case, they're not doubly vaccinated, then you can dismiss somebody for effectively capability. It's the one you would use for performance management and sickness absence. No one knows which one is likely to be fair. The courts will decide that, not DHSC or indeed Emma Burrows or anyone else. It's up to the courts to decide what is fair. So my advice to employers is to include a number of them. And I think that the best options are that it's in breach of a statutory enactment to continue employing somebody, and separately, it is probably a good reason to protect the health and safety of colleagues and the people you support, and that's why you're dismissing for some other substantial reason. Now, there is an advantage to dismissing for some other substantial reason, which is normally when you dismiss somebody under the ACAS code, it's good practice, and under general law as well, to have an appeal. But there's actually recently been an appeal, a case which found that where an appeal was futile and would not change the reason on some other substantial reason dismissal, that there was no point, that it was still fair to dismiss someone without giving them an appeal. So if you wanted to rely on that, it would be sensible to include some other substantial reason among the reasons for dismissal, and you should include those on the letter and advise people in the meeting where you dismiss them. So Jennifer has said, can you expand on a fair process? And I think at the very minimum, Jennifer, what you need to do, and this is subject to what your relationship is with your employee representatives and unions, is you should have a consultation meeting with individuals. to talk to them about why they're not being vaccinated, you know, what the issues are, do they understand what the implication is, to talk through. I think it's very helpful to talk through what they're going to do next, because I do know employers who said, well, they've said the in-staff will say, well, we'll just sign on with an agency and we'll probably end up with you. And the employer said, well, no, because agencies also have to require people to be vaccinated. And that has been a push towards some people being vaccinated. I have to say, I also know that, I mean, obviously the recruitment issue in care at the moment is a bit of an issue. And I know lots of other employers who are saying, well, our staff are actually going to the NHS where you don't need to be vaccinated, which is slightly less depressing than they're going to Amazon or they're going to Tesco's and earning £2 more each, you know, an hour or something. But it is difficult to manage that. But I think it's worth talking all that through in a meeting, giving someone the opportunity to go and have a vaccination, and then subsequently, if they refuse, and ensuring that you know that they have refused, so speaking to them again or asking them to upload an attestation that they have been doubly vaccinated, even showing you their COVID pass this early on is sensible. If you're satisfied that they have not been vaccinated, then you have to have another meeting to terminate their employment. And that is good practice, and it's worth looking through the ACAS code again, which sets out what's required of you at any meeting where you terminate employment. So Nathan's asked a bit about the self-certificate of exemption, and I see Amanda has sent that round, but that was yesterday. The temporary medical exemptions was sent round, and it involves employees self-certifying that they're unable to have the vaccine. And no, the issue there, they do not have to upload any medical support to that, which is why my staff are actually quite worried, my clients are quite worried about that, because they think that people who are not being vaccinated, have refused to be vaccinated, might self-certify. And indeed, today we've been talking to a client who is absolutely convinced that this is what's going on, and talking to her about whether she should give notice now to staff to say, unless you provide us with the NHS pass within 12 weeks of it, you know, within 2 weeks of it being available, we will dismiss you. So giving them notice now, so their notice runs until they can do that. But I'm concerned about that approach. I think it's a bit brutal. And also, if people are genuinely disabled, I think it was quite offensive as well.
Yeah,
so.
coming from us, Emma, is there's a really good list from Alison on the exemptions, and we'll certainly pull out all of those medical exemptions, although they're not completely exhaustive, but they do cover an awful lot of different areas there. And yeah. Amanda's, I believe, has come in. Oh, sorry, I beg your pardon, is Lisa right? Clarifying the question around pregnant colleagues. Can they just be pregnant and exempt rather than pregnant with a medical condition to be exempt, which was the latest guidance prior to?
It looks like it's just pregnant. Yeah, Alison says just pregnant. Yeah. Which is why it's so interesting, actually. This is what I was saying earlier. It's really interesting development, I think.
Yeah, and it's a point of technicality here. We did hear a while ago that the COVID pass through Android wasn't working as effectively as possible. So if providers have had experience of staff not being able to share their information because they haven't been able to get access to the COVID pass, that would be really helpful for us to understand and feedback to NHS colleagues. There's another key concern, I think, which is around, while it's okay for exempt workers to remain employed, but other unvaccinated have to be dismissed. Why is that?
That's a big policy issue, Joanna. I think you need to put it to someone other than me. I'm just a mere lawyer.
It's really helpful. And you talked very briefly at the beginning about the judicial review. In terms of a quantifiable timeline in your legal expertise, even if there was a judgment, do you think then there could be a
delay?
A delay, yes, any subsequent retrial of any decision, so appeal.
I think it's entirely possible. Regulations can be withdrawn by government at very short notice. I don't know if any of you are in the public sector, but earlier in the year, they pulled regulations which were due to come into force, limiting exit payments to, I think it was £100,000, something like that, £90,000, I think. And they were due to come into force, and they pulled them 2 months before they were due to come into force. So it's entirely possible that government can do that. I think a lot depends on the strength of the judicial review, and it's on 5 grounds. I'm not convinced it's going to be successful, to be honest. I would love to be, I might go along if I can to hear it, but I don't think it's going to be potentially successful. It says, I'll tell you a bit about it. It says the regulations are incompatible with other laws prohibiting the enforcement of mandatory vaccinations. Some of you will recognise that from the COVID-19 assembly letter that we've all had, we've all seen. The second is the health secretaries failed to consider the efficacy of alternatives, so basically PPE, to mandatory vaccinations, and did not consider the vaccination rate of care homes individuals and or persons with natural immunity, which I think they do. The regulations interfere with the public's right to bodily integrity and is severe, unnecessary and disproportionate. So that's really a policy decision about whether the government can require us to take some poison into our bodies, really. Of course, there is precedent that they do that already with hepatitis injections in the NHS. The regulations disproportionately impact on women and those who identify as Black, Caribbean, Black, British, and they're saying that is a discriminatory. And yes, I haven't seen any evidence that it disproportionately affects women. And there's lots of discussion within the public sector equality duty papers that the government has issued about the effect on Black and minority people. And the conclusion of the government in each case is you are disproportionately affected by COVID, therefore you should have a vaccine so that you are not disproportionately affected by COVID, and a vaccine is a good thing. So whether or not that argument wins is really up to the judge. And then there was one other reason as well, which is that the consultation wasn't effective and is irrational and will lead to shortages in both frontline and non-frontline care workers. Well, I think we probably all agree with the second half of that. I don't believe that the regulations followed the consultation. The regulations go much further than the consultation did. So that is potentially judicially reviewable, but I don't think it would necessarily lead to a repeal of the regulations.
Thank you. A good question here from Sabrina, and then I might also bring Alison into the conversation because there's one on CQC, and I'm sure Alison Marie will be able to support us with a bit more of a clarification on certain policy updates and regulatory position. With the temporary exemption process and care workers having 12 weeks to apply for exemption following the launch of the full process in the NHS app, what will that mean in terms of the timeline deadline of the 10th of November?
Well, the temporary exemption process is live, so employees can self-certify as of immediately. So, and that will last until the NHS app is working. And I don't know, how far off we are from that. I mean, the travel app works fine, so I'm not quite sure why there is an issue there, but the idea is to have the NHS COVID pass. Sorry, it's just disappeared. So I don't think it really matters the deadline of the 10th of November. You may start on the 10th of November using the temporary exemption form if the COVID app isn't up and running. I mean, we were hoping for it to be up and running in June, and it's not yet. Robin says, do you think that the way the medical exemptions have been handled somewhat chaotically makes a successful JR more likely? No, I don't, Robin. I think now that we have the temporary exemptions isn't great, the way that it's being handled, clearly, but the idea that there is a medical exemption and that it does follow clearly most of all the green book. I think the fact that they've actually now, put out some information shows that it's being more reasonably implemented than before. So, yeah. Amanda says, CQC say you just need to see a document that you've seen it. Don't understand that one, sorry.
I think we'll let Alison pick that up and time
Yeah.
frames. And Alison, can you hear us? Would you like to come in?
Oh,
Hello.
yeah, sorry, there is one other thing, which is Emma says some providers are under the impression that care home workers can get first and second doses of vaccine 4 weeks and have been told this by GP, so not concerned about the 12-week time frame. I've heard that too, and I have to tell you, my teenager got the vaccine with a 3-week delay between both, so it's clearly possible. But I'm interested to know what other people say about that.
Thanks, Emma.
I think it'll be really interesting if someone's here that can answer that one. Great, Alison, thank you. Okay, well, please let me know if there are any other questions.
Right. Hi, everybody. Those of you who don't know me, I'm Alison Murray. I'm Head of Inspection for Adult Social Care and CQC, and since the beginning of March last year, I have had the absolute joy of being seconded to focus full-time on COVID-19 and its application and response within adult social care. So, Emma, that bit about your teenager, that should not have happened. Can I suggest that you raise that as a complaint with your GP, because that is clinically not effective? It really shouldn't have happened.
I will, although she had the Pfizer one, which all her cousins in France have had, and they're doing it at 3-week intervals there as well.
Yeah, they're doing it at 3 weeks in France, but UK, the JVCI advice is minimum 8 weeks.
Okay.
Sorry. Yes, and where I have to say that when I know that when we've heard that GPs have been doing this with shorter time frames, we have actually followed that up from a regulatory perspective. Okay, so vaccination is a condition of a deployment and HR issues. Now, first of all, you know, as a CQC person, I can't give you HR or employment law advice. What I can do, and what I thought might be helpful in this particular meeting, is just to reflect a bit about the guidance that came out yesterday and what that means for people. So I think that we can all reflect that it was a source of frustration that we've had to wait for so long before further guidance came out on the medical exemptions criteria, and also that it's so close to the 16th of September deadline. It's definitely not ideal by any manner of means. The additional guidance that's come out, I've posted the broad criteria in the chat, but please do have a look at the letter that Claire Armstrong sent out yesterday that should have gone out to all care home providers, and it was also included in the Department of Health and Social Care's bulletin yesterday and is also available on their website. It gives a little bit more detail about medical exemptions, but I have to say there is still ambiguity that I'm sure will be causing you anxiety and challenge. The self-assessment process, again, isn't ideal, but actually it may be helpful in the short term. And just to say that the templates that the departments put out for staff to self-declare their medical exemption are quite nicely and clearly written in plain English. And they do have a little bit on the bottom that says, I recognise that if I give fraudulent information, this may result in disciplinary action, which may be some small comfort to you. Probably not a lot of comfort, but maybe some small comfort to you. So the criteria are quite broad, but do narrow it down a bit and certainly easier to read than the stuff that's in the Green Book chapter. The bit about pregnant women, I have to say, came a bit left field. I think that one caught all of us out because that wasn't quite what we were expecting, but it's very clear that people who are pregnant and choose not to have the vaccine during their pregnancy can apply, can put themselves down, self-certify as exempt, and that is absolutely fine. There don't need to be any medical conditions, any complications of pregnancy behind that. It is purely the fact that they're pregnant. And I know that the department's looking to see if those people will need to go through the full medical exemption process, the NHS pass service once it gets going. A conversation that I had with them last night, we were thinking that it may be that actually just something from a midwife or a MAP B form might suffice, depending on the stage of pregnancy. My understanding, and again, if this is just purely my understanding, is that there's still a lot of work going on in the background to get this COVID pass system up and running. It sounds as if it will probably be some form of application to 119 and then some form of assessment ratification process and generating some sort of app-based thing that will allow somebody to demonstrate, to show visually that they have a medical exemption. To be absolutely clear, there is utterly no expectation whatsoever that the individual will need to disclose what that medical condition is to either their employer or to CQC in any manner whatsoever. It's purely going to be, first of all, I declare that I'm self-exempt for medical reasons, and then once this pass system comes in place, the pass system will generate just a tick or a cross or some form of very, very simple display that will say, I have a medical exemption. And to pick up one of the questions that was in the chat earlier, again, CQC will not need to see that evidence. All we'll want to see is something that confirms that the registered person or the person acting on their behalf has seen that information. So again, we want to try and make this as easy as humanly possible for you. And from our perspective, we don't see a problem with one of your staff members simply showing you or the registered manager their self-declaration form to say, I'm saying that I'm exempt. So that's the sort of stuff that we're going to look at on inspection, and the fact that somebody is medically exempt and has shown you that bit of paper will be absolutely fine with us, and they can continue working in your service whilst they apply for any formal process. Clearly, it would be sensible for you to have done some form of risk assessment about this, as you would do for any of your unvaccinated staff, and see whether or not there are any enhanced IPC measures, any enhanced PPE that you need to put in place. But that will be your decision, but do a risk assessment and show us that risk assessment when we come out and inspect. That would be really, really helpful. In terms of timeframes around the NHS pass service, I haven't got any inside information about how quickly this is going to be up and running, but just to be absolutely clear that the intention is that the temporary self-exemption period will continue for 12 weeks after the COVID pass service goes live. And the rationale behind that, I understand, is that that 12 weeks will then give an individual time to take clinical advice, to apply to the NHS app system, whatever that system is, to have got a decision from it. And if for any reason the decision is, we're really sorry, actually, we don't think you're medically exempt, then give them time to have both doses of the vaccine. So tight, but doable. I think that's probably all I can think of to say about this at the moment, but again, very happy to pick up panel questions.
Thanks very much, Alison. We'll go back to some questions. I can see a few more have come into the chat while we've been speaking. I think we've answered Lisa's question around the grace periods for those who are temporarily exempt. Alison's just given an answer to that. There's a question from Mariana, which is around the relatives of residents who are visiting are not required to be vaccinated.
Do you want me to?
Yes, please.
To pick that one up with a probably non-answer. The bottom line is that that isn't the government policy and that isn't what the regulation says. My understanding is that the rationale behind that I think is actually covered in the guidance that the department's put out, is that they recognise how difficult it's been for people using care services to not see their relatives over a large period of the past 18 months, and they're very, very wise to the impact that that's had on people, and they want to try and make things as easy as possible for people to see their loved ones. Whether it makes sense or not is an interesting moot point, but I think that was the rationale behind it, not to try and put any more barriers between people people seeing their loved ones. But clearly we would love to promote vaccination as much as humanly possible and would encourage everybody to have it wherever possible.
Thanks, Alison. Another useful question here around overseas visiting. So we've had this one come before, particularly with reference to, is Johnson & Johnson overseas vaccination record valid as proof of evidence?
At the moment, I mean, again, yeah, clearly I can't speak on behalf of the department because I'm CQC rather than the department, but the stuff that they put out yesterday seems to make it clear that anybody who's had any form of COVID vaccination overseas is able to say that they're exempt from this regulation for the moment. The exemption certificate that's been put out there, the template one that's been put out there, says something along the lines of, we may need to look at this again in the future. My sense is that if people have had vaccinations that are approved by the MHRA in the UK, then that should be absolutely fine. The slight technical difficulties may come for the people who've received the vaccines that haven't been approved by the MHRA for UK use, things like the Sputnik and the Chinese vaccine. A really tricky area, no easy answers. At the moment, they're fine to continue working, but we don't know what the future is going to hold on that.
Thanks, Alison. I think there's also a really interesting question which is from Lorna. So she has a worker who had her first dose in Wales and the second dose in England. The information from the devolved nation Wales has not been shared, so she can't obtain her NHS COVID pass on the app. Is it acceptable as her employer for us to see the evidence of the second dose and accept this until she's able to resolve it?
I see no reason why not.
Yeah, thanks. And then boosters are not currently included, but in due course.
Yeah, at the moment, boosters definitely aren't included because at the time that the regulations were drafted and laid in Parliament, a full course of vaccination was the two doses. If the political desire is to include the booster doses in this legislation, then they will need to amend the regs to include that.
Thank you, that's helpful. And then just a point of clarification around the certificates of exemption again. Just to be 100% clear, is it correct that we wouldn't state the reason, it's just the fact that the individual is exempt?
Yes.
Thank you. And there's something about, so I've heard this as well from a number of members saying the original vaccination cards, you know, the more sort of paper-based card that people had as appointment cards originally, but they had the batch numbers and dates written on them. Is it actually going to be suitable to use those going forward?
I'm afraid not. They're explicitly discounted from the guidance that the department's put out. I mean, one of the reasons for this is, I don't know if any other people have the same experience I did, but I was given my own one to fill in and given a couple of spares in case I wanted to keep different ones in different purses. So no, it will be on the COVID app or on the NHS app, not your little piece of paper.
Thank you. And this might be more of a Emma question. If you have two members of staff, both who've had one vaccination but are not willing to have the second, what would be the legal position with their employment status going forward?
Well, very sadly, if they haven't had two vaccinations, then they are not going to meet the regulations, and they will have to otherwise be redeployed if you have a redeployment, or otherwise their employment will be terminated. But they've got quite a long time to change their mind. Got 8 weeks.
Yeah. And just to be absolutely clear as well, what we've heard from DHSC policy advisors previously is that you can have staff vaccinated up until the final day of the implementation of these legislations. So I think we had a technical question about did it actually need to be 2 weeks before the 16th, but it's not the case at the 11th of November. Apologies. Emma, yes.
There is actually a very interesting point on that, because the current NHS app takes some time to update. So even though you have your double vaccination on the 10th of November, the organisation may not have any proof of that for some days, 5 days or 2 weeks, depending on whether someone relies on the app technology. So unless the app technology changes from what is there already, there is going to be a delay. And during that time, you would have to take the employee on trust, which I'm sure you'd want to do that. But obviously there's, you're open to fraud in that case. But also move them out of the building, so that, unless you've got the proof, you couldn't deploy them on the front line. So you'd have to either agree unpaid leave or let them take holiday, or otherwise just pay them to be at home. So it's additional cost.
And what would be the situation? We had another member that explained they feel that the majority of the workforce is actually vaccinated, but they've had significant problem in collecting the data. So they had around 500 staff where they didn't have full records currently of vaccination status. It's probably a both and question, really. Alison, if, for example, the inspector was to turn up at the door on the, 19th of November, for argument's sake, and they only had a third of the workforce data collected, what would be the ramifications for those individual providers?
Oh, an interesting one. I mean, what one would hope that the fact that technically these people, if they haven't provided evidence to the registered manager that they've been vaccinated, then technically they shouldn't be working in the service. And the fact that actually that might mean that they weren't being paid, then one would hope that that will prompt people to show that evidence. When we go in and inspect, what we're going to be doing, clearly when we go in and inspect, we don't look at every care record, we don't look at every staff record. We ask the provider, what systems and processes do you have in place to demonstrate compliance with this regulation, and we sample. So it's a really difficult one to answer either yay or nay, but the registered manager is held to account for this, and if the registered manager has not got those systems and processes in place to demonstrate compliance with the regulation, then actually they're technically in breach.
Thank you, that's helpful. Question from Melinda: is it reasonable for the registered manager to defer confirming the vaccination status to the line manager of the employee who needs to be double vaccinated? I'm not quite sure why you would want to defer confirming. No, because people, it was actually visually seen. There's a comment here about people who
Yeah,
in the
I
first
can,
wave actually,
yeah,
staff
I
and residents were vaccinated together, so they know
yeah,
because they had seen it.
yeah, I'm afraid having seen them isn't actually, doesn't fulfill the requirements in the guidance about demonstrating that somebody's been vaccinated. That's quite explicit, but it does need to be the COVID app, the COVID pass, or a letter from 119 if they're not if they don't have digital stuff.
Yeah, that's great. Has anybody got any further questions?
Would it help if I just also quickly, just to finish off very quickly, said that, you know, of course, this regulation comes into play, it becomes enforceable on the 11th of November. Now, we have 500 and odd inspectors, and there are 15.5 care services. We're inspecting, prioritising to risk at the moment. So please believe me when I say that we aren't going to be beating your doors down to enforce this regulation. We'll be scheduling our inspections as we would normally schedule them, according to our risk priorities. And yes, we do get information from things like Capacity Tracker about, you know, vaccination status. We think we may well get whistleblower or information of concern shared with us about people's vaccination status, but it will be just one of the things that we will look at in the round to help us make our regulatory judgments of when we go out and inspect. Hopefully that might be some comfort.
Yes, I think it will give lots of people comfort, but the point is still that there's a process to be gone through and there's a time frame to complete it in, so people are working extremely hard, I believe, in the background to try and get this done. I think the point of the clarification in that question was around, can the register manager defer to other line managerial staff within the organisation to look at the criteria? And I would imagine it depends on the size of organisation, but as long as the register manager's got significant confidence in the data that they're picking up from their management teams, then yes, that would certainly mean sensible. Great. Thank you all so very much. We are sharing a recording of this session with the Eventbrite registrants and participants. We will also update, the CPA has a specialist section on its own website specifically for questions and answers and more support information for providers around vaccinations, condition of deployment. We will keep amending it and updating it, so do use that link and stay in touch with us via the info@Care Provider Alliance email address that will also be circulating should you have further questions or concerns or wish to raise any particular issues. Thank you very much indeed. Some lovely feedback saying superb speakers. Thank you very much. My colleague has just popped the info in the chat, but we will circulate copies of the Q&A and details of how to be in touch with us all after the event. Thank you very much.